Hi guys. Sorry, I forgot to turn my intro off. But that's alright. It's only a few seconds. As long as I don't play my outro. Hi guys.
Oh,
Sorry, I forgot to turn my intro off. But that's okay. Now we got a second stream going immediately after our first stream. Okay. So we're on January 25th. Um they're still doing their opening statements. Hi Salty. No, I didn't see Judge Wolf yesterday. I almost did, and then I switched to a different judge right at the last second. I was this close. Is it still possible to get it? I wonder, or is that one of the ones that he takes down right away? Anyway, here comes Simpson. I don't know who that is right here, but I'm sure we're gonna find out if they show it to us. We're on 35. We're on the right one. I know it. I don't hear anything. Of course, I don't hear anything.
uh, there he is, right behind you.
Oh, there you are. I, I thought Mr. Cochran was hiding from me, and perhaps Willie should. Okay, no, I see you, Mr. Cochran. And, Your Honor, let me say this. I was about to say, you asked me to examine the record for instances of inappropriate remarks for an opening statement. I want to make the people's position absolutely clear this afternoon with regard to when objections are likely to be opposed, because I want to give Mr. Cochran fair notice. What we heard in large part this morning was not an opening statement, but could very well pass for argument, and if given an argument, would not be objectionable. But this morning, and as I stated to the court, I am reluctant in any case to interfere with opposing counsel's opening statement. It was with great restraint this morning that I did object to a number of clearly objectionable remarks made by Mr. Cochran. I will highlight those just in just a few moments. However, Your Honor, what the people are seeking this afternoon is, first of all, an admonition to Mr. Cochran not to engage in argument in the guise of an opening statement. Secondly, with regard to various passages, which I will highlight and pinpoint for the court in just a moment, I'm going to be asking for a motion to strike, and in addition, an admonition to the jury to disregard such statements, because not only are they not evidence, but they are improper remarks for an opening statement, and the jury should be so advised. In addition, Your Honor, after I address the opening statement issue, I have an additional issue to raise with regard to discovery, because it appears we are about to revisit the events of Monday to some degree. I will begin, Your Honor, by stating generally many of Mr. Cochran's remarks were in the form of a rhetorical question. Many of his remarks were in the form of a personal attack on my colleagues, Ms. Clark and Mr. Darden. Such remarks are not fitting nor are they appropriate in an opening statement. Absolutely 100% not fitting, not appropriate.
I'm guessing the jury's not in here. What do you think?
Let me give you just a few examples, and I have to cite to the reference that we were given off the disc that the court reporters were able to provide us. For instance, and I cite to what appears to be 0553 of this morning's transcript, where the defense argues that this case is about a rush to judgment and obsession to win at any cost by any means necessary. Your Honor, such a remark is fitting for argument, perhaps, not fitting for an opening statement. Clearly, that is outside the bounds. And again, Your Honor,
Mr. Heitman, how does that compare to Mr. Darden's argument that the issue is that you have to establish the relationship and that the person who is guilty of this crime is a wife beater, batterer, controller, blah, blah, blah? Sounds like the same argument to me.
Look, does the court intend to make an equity call? I'm simply posing to the court
No,
things
the
that I
problem
found
is-
to
the
be
problem- no,
objectionable.
Mr. Hodgman, here's the problem. Each side has to present what their theory of the case is. That involves some type of short explanation as to what that argument is going to be, and here's the evidence that's going to back up our theory of the case. That's opening statement.
And I understand that, Your Honor, and you stated a short,
Yes.
and I would submit to the court that based on what we heard this morning, that line got crossed very, very early on. I will continue.
Mr. Hodgman, let me do this.
Poor Snoopy.
And please forgive me for interrupting you again, but we did discuss this also informally. My suggestion is that we do this. Because we have to break early for one of the jurors' medical appointments this afternoon, let you put these matters on the record when we conclude. Let me just caution at this time, Mr. Cochran, because I did mention to him that I felt that we were about to cross over the line into argument. You can tell him what the theory is. Mr. Hodgman, they are entitled to say that the prosecution has indicated this is their theory of the case and how they're going to proceed. And he's entitled to say this is what we're going to present to counter that. And he gets to explain how they get to do that. Now, I agree with you that evaluating it and saying that your case is trash for this reason or that reason, that gets into argument. I agree.
Okay. And
All right? I will be more... I
Okay, wait. What is going on down here? Is this just like torn? Is this a tablecloth that's like falling apart, unraveling down here? Look at that. And look at look at all these wires. Yeah. I don't think so. Okay, you see how sharp this point is right here? Wires don't normally do that naturally. Cloth does. I suspect, you know what? I don't know though. I don't know.
My feeling was that the defense gave both Mr. Darden and Ms. Clark wide leeway in arguing and presenting their opening statements. All right?
But what the defense didn't do yesterday, Your Honor, was engage in rhetorical attacks upon opposing counsel, such as, why didn't Mr. Darden tell you about this yesterday? Why didn't Ms. Clark state something else yesterday?
I agree. I agree.
Argumentative and...
I agree.
Okay.
So what can be said is that the prosecution did not give you a complete picture. We're going to add this piece, and this piece for a clear picture. I think Mr. Cochran can phrase it that simply without referring to what the prosecution said.
Okay. We have additional language, and I raise this now, Your Honor. I will detail these objections more clearly at the time suggested by the court. But time and time again, Mr. Cochran stated this morning, and you would have to believe, and you would have to believe, and then you would have to believe, time and time again, which again, Your Honor, this goes to argument, not to opening statement. Opening statement is supposed to be a recitation of the evidence that they expect to produce. And what you have clearly is argument. This is entirely inappropriate language, Your Honor.
Counsel, I've chosen to caution Mr. Cochran. I can tell by his response to me he takes my caution seriously. Although I'm beginning to feel like the Rodney Dangerfield of judges these days. In fact, I'll have to call Barry Langberg later today. Mr. Cochran, you will take seriously my caution. All right.
Okay.
I just want to get the ball rolling today because we have a short court day.
And, Your Honor, and I agree with you, and the only reason I raise this now so that we can have appropriate opening statement this afternoon. Reference to hearsay, I lodged my objection this morning. I trust that the court and counsel understand the basis for that. I would point out as well that based upon the record produced thus far in this case, that reference to Mark Furman by name should not have been made. Based upon, no, I am referring to page 11479 of the record. This is Monday, January 23rd. The court states, I am precluding the defense from making mention of Detective Furman during the course of their opening statement solely on the basis of the fact of the late turning over of other statements of Kathleen Bell today.
And what
I thought that
happened-
was pretty clear, Your Honor.
What happened later in the record, there was a request for clarification. I indicated that they could not mention Detective Furman in the context of Kathleen Bell. They could mention his participation in the investigation, however, not in the and they could not, in opening statement, mention the Kathleen Bell aspect.
Very
There was a later clarification in the record.
Very well, Your Honor. We'll stand by that clarification. Then the last point I'll raise, and I will raise this in greater detail this afternoon, I know the court wants to move along, and that is the discovery issue. I can point out two names in particular this morning that were mentioned in the defense opening statement. Marianne Gertjes and Joe Stellini. These are names which are on the defense witness list, but the way Mr. Cochran referred to these witnesses this morning, it was evident that these witnesses have been interviewed, that there have to be statements outstanding someplace. Now, we have gone through this over the past couple days. The defense is supposed to disgorge witness statements to the people. And, Your Honor,
I have in my notes that these are items as well that I was concerned about. So
and
let's
I share the court's concern, Your Honor. I share the court's concern for this reason, because as we have stated throughout these proceedings, going back to late June and early July in municipal court and superior court.
Please forgive me. I recognize it as a discovery issue. We'll take it up as soon as we get the jurors on their way at 3:30. Then we'll have a full hour that we can sit and talk about this. I am concerned, and I do recognize it as a discovery issue, and I'm going to make further inquiry.
Very well, Your Honor. What I'm concerned about is the prospective aspect this afternoon when Mr. Cochran speaks. What else are we going to hear about? The people are being denied their right to a fair trial, Your Honor. That is what's occurring. This is surprise. The court sees the issue. The court sees and senses our concern. It is happening in opening statement, and the people have not received reciprocal discovery. I think that is evident to the court. The people are not getting their fair shot, Your Honor.
All right. All right, let's have the jurors, please.
Nope, it's not just you. Thank you, Snoopy. Thank you. I hope you're feeling better soon. One day at a time. Don't rush it. Don't make it go too fast.
Your Honor, may I send the witnesses home?
Mr. Cochran?
I think that's starting to get, we're cutting our time. Oh, see that now. We have taken 10 minutes from Mr. Cochran's time.
All right.
And what time would you like them back tomorrow?
9 o'clock. What did that mean, Mr. Darden?
My law clerk. Yeah.
The jury was in the room, or they're coming in. They're coming in now.
All right, let the record reflect that we've been rejoined by all members of our jury. Be seated, ladies and gentlemen. Thank you. All right, ladies and gentlemen, at this time we will resume with Mr. Cochran's opening statement. Please remember that the opening statements by the attorneys are not evidence. Mr. Cochran.
Thank you very kindly, Your Honor. Good afternoon, ladies and gentlemen. When we broke this morning, we had just gotten to the point of discussing the coroner who previously testified in this matter, Dr. Golden, and I think I alluded to the fact that in the course of the opening statement yesterday, we didn't hear his name. And we expect that he will, in fact, be called in this case. Either if people don't call him, then we will. And I think that you will hear evidence to the effect that you can, in fact, determine the time of death with greater precision than you heard yesterday. That if one is qualified, one can look at the state of rigor mortis, the state of lividity of the body, state of the temperature of the body, and also the ambient temperature, use things like the stomach contents. In this case, there was a major problem. Dr. Golden's testimony is that he would place the time of death between 9 and 12 o'clock. Now, between 9 and 12 o'clock, you now have heard enough of the evidence to understand that at 12 o'clock, Mr. Simpson was in the air, and at 9 o'clock, there'll be testimonies you've heard as to where he was at his house. So we have a problem with regard to trying to fix the time of death. And you heard the prosecution's theory yesterday about the time of death being about 10:15. You've heard from me this morning that the defense advances the theory that that's clearly wrong based upon the witnesses that you've heard. Now, with regard to Dr. Baden, who is our expert, and I should tell you a little bit about him, Dr. Michael Baden is a former forensic pathologist, the chief medical examiner for the city of New York. He resides in New York. As I said, he has worked for the LA County District Attorney's Office in the past. He's considered one of the foremost forensic pathologists in America. He came to, the evidence will be, he came to Los Angeles shortly after Mr. Simpson's return from Chicago, and in fact went to the LA County Coroner's Office that week, the week of June 13th. And it was after Dr. Michael Baden's conferences with Dr. Golden and his superior, along with Dr. Baden's colleague, Dr. Barbara Wolf, that the coroner's office wrote a letter to Mr. Hodgman with an amendment to the coroner's report they'd filed. And I'd like at this time to turn our attention to the graphics. This is a letter that is directed to our colleague, Mr. William Hodgman. You'll see Mr. Hodgman there. And we'll proceed on.
D88. D88.
It'll become clearer.
Your Honor, excuse me. I have an objection to interpose. I wish to approach at sidebar, and I would like this image stricken from the screen for a moment. Very well, Your Honor. I withdraw the objection.
Thank you. All right, Mr. Harris.
As I was indicating to you, I think that this is a letter to Mr. Hodgman, and you can move to the next one, Mr. Harris.
That was D89, the highlight. That's D90.
It's an effort to make it clearer for you.
D91. D91A, this is D91.
You can now see what's happened here, that the letter, the lines have been blown up so you can see them more clearly. And you'll be able to see them yourself. I don't have to read those, I don't think.
D92A. D92B. D93A.
Now this one, if I might stop for a moment, this would be one that's very important. I'd like to read this. The stomach contents of Miss Nicole Brown Simpson were not saved. And you will hear testimony during the trial that if the proper procedure for any coroner's office in the United States, they wanted to determine with some accuracy the time of death would be to save the stomach contents. In this case, the coroner's office threw those stomach contents away. We will never have those. May proceed, Mr. Harris, please.
That was D93B. D94A. D94B.
This has to do with the mislabeling of a sample regarding Mr. Goldman. You may move on, Mr. Harris.
B95A, B95B,
Once he stops fast forwarding through picture to picture to picture, the beep should go away, Mel. But that's so cute. That is so cute. Good night, Rebecca.
It's another mislabeling or inadvertence. Move on, Mr. Harris, please.
B96A, B96B,
This has to do with a procedure which was violated by the coroner's office, which they acknowledged in this letter. After being separately dried, the panties and dress were wrapped together rather than separately. Mr. Harris, thank you.
B97A, B97B,
This has to do with the media, the ever-present media. We'll move on.
B98A, B98B,
It's an interesting one with regard to a recommendation that it would be desirable to perform a response team on complex cases by adding a pathologist, criminalist, and a coroner's photographer to the coroner's investigator and transport persons routinely assigned to respond.
B99A, B99B,
This one called to your attention also that the coroner's office response team was not allowed access to the decedents by LAPD until approximately 10 hours after the LAPD's arrival at the scene. That will become, we think, important in the evidence, and we will share with you a transcript of a conversation between one of the detectives in charge when the call was first made and asking them not to come out at that time. Our experts will testify that if one wanted to determine the time of death, the coroner's office needs to be called as soon as possible to respond to the team. Mr. Harris, sir?
B100A, B100B,
Mr. Harris, you may move on.
B101A, B101B,
Mr. Harris?
B102A, B102B,
Fluoroscopy would have been desirable. Apparently it was not done in this case.
B103A, B103B,
Indication that photographic prints should have been made by the Sheriff's Department rather than LAPD, the coroner's office being an agency of the County of Los Angeles.
B104A, B104B,
All right, Mr. Harris?
B105A, and B105B,
Mr. Harris?
B106A, and B106B.
Thank you, Your Honor. Thank you, Mr. Harris. We finished that one. Now, ladies and gentlemen, as I indicated to you, what you've just seen and what we expect to be the evidence is that those are basically amendments to the coroner's report brought about after this conversation and meeting between the LA County coroner who did the autopsy here, Dr. Golden, his boss, Dr. Lakshmanan, and then our experts.
Okay. Your doggy should be okay now. I think the beeps are all gone. Poor Mel.
Now, we expect that when Dr. Baden is called to testify in this case, he'll make a number of findings because he was there, was able to review all these records, and we expect the evidence to show, while we're talking about coroners, that he will testify that the injuries and bruises on Mr. Ronald Goldman's hands indicate that he had struck his assailant, and yet there was a fight, a major fight, prior to his death. That proper forensic procedures would preserve the stomach contents of the deceased, as I've indicated to you. That in this case, there was no rape or semen kit analysis performed, and we would expect that the expert would testify that a semen rape kit analysis is standard procedure for coroner's offices in the United States at this time in June of 1994. You will also testify, I believe, that closer to the time of death, one takes the temperature of a victim, their livor mortis and their rigor mortis, as the likelihood of an accurate result increases. And that's very important. He will say also, I believe, that the killings would have resulted in an enormous amount of loss of blood. And of course, you've seen that evidence of which would be expected to be on the perpetrator. It would have expected the person who committed these horrible crimes would be covered with blood. Dr. Baden and along his colleague also Dr. Wolf examined histology samples and pointed out to the coroner's office a bruising of the brain that Dr. Golden had missed. They pointed out some findings that their coroner's office had actually missed, and they advised them and let them know. There was then a supplemental report filed regarding that also. Dr. Baden, as the expert, will testify that the L.A. County Coroner's Office violated their own procedures in performing these two autopsies. He will indicate further that the autopsy findings in this case are consistent with the struggle that resulted in hand-to-hand combat, that Mr. Goldman did in fact bleed profusely and he bled slowly, and that he was standing through most of this, and that in his opinion the perpetrator would be covered with Mr. Goldman's blood. Also, Dr. Baden will testify that there are blood drops on the back of Miss Nicole Brown Simpson, and there were no swabs taken. In fact, when the body was moved and taken to the lab, those blood drops, which very well may have been of the perpetrator, were wiped off or washed off, never preserved. And so, what I expect the evidence to show through our testimony and through cross-examination, as I've indicated, that the coroner's investigators who came to that scene.
And Marcia said that they couldn't find his clothes. His clothes just disappeared.
Also didn't wear any covering over their shoes. But we expect you'll be able to see that this scene was tracked through and traipsed through by the coroner's people, just as it had been by the LAPD people. And at some time in this trial, we hope to have some graphic video evidence of that fact to you so you can see for yourself. But in short, what, from our standpoint, from the defense standpoint, in wanting a fair trial, being able to defend our clients, the actions of the coroner's office has obviously made everyone's job, and specifically the defense's job, much more difficult. That when the LAPD failed to notify the coroner's office for 10 hours in violating the state law, it made everybody's job more difficult. That Dr. Golden, if and when he testifies, as he testified at the preliminary hearing, when asked questions as to whether or not there could have been 2 knives used in these 2 killings, will indicate that some of the wounds on these 2 victims are consistent with a double-edged knife. Some are consistent with a single-edged knife or blade. So they would be consistent that perhaps 2 knives were used. And I think that we can expect that from his testimony either by the people or by us if he is called to so testify. In addition to Dr. Michael Baden, we will have for you to testify Dr. Henry Lee, the foremost forensic crime scene analyst in America. He is head of the state of Connecticut lab. He'll be here to share with you his findings with regard to this crime scene and what took place at that crime scene and the contamination of the evidence thereof. Now, with regard to the opening statement yesterday, as I said, you were told that in this case, the coroner's office couldn't do any better than 3 hours. And I think that with the evidence we've shown you, we're going to show that they could have done an awful lot better. And we'll have other cases to cite for that. I've covered with you this morning the question of the timeline. We'll talk about that at the very end again. Ms. Clark talks about a trail of blood where there is no trail. And we will expect to have evidence showing that whereas she told you yesterday, time and time again, that they were looking for matches to exclude, that what she did not tell you was that there are trails that lead toward innocence, and they were not pursued. Let me give you some examples based upon the evidence that I expect to produce in this trial. There is, and I'll go through this list for you. Expect the evidence to show that there was blood under Miss Nicole Brown Simpson's fingernails. It came back a type B in an EAP genetic marker. And that does not fit the genetic profile of Mr. Simpson, Mr. Goldman, or Miss Brown. Some other person. That there was blood found on Miss Nicole Brown Simpson's thigh. That came back also a type B. There was, as you might imagine in this case, all kinds of evidence that's come forward, people who want to volunteer things. There was a knife found shortly after
I mean, if there's going to be a drink there, I mean, yeah, I'm going.
these killings. And the blood on one of the knives found also was this type B, similar to the blood that was found under Miss Nicole Brown Simpson's fingernails. You would expect that blood would be of the perpetrator since it's not hers. We will, in a short time, show you a graphic of several things in that connection. There were identifiable fingerprints which not match and don't match Mr. O.J. Simpson or any of the police officers there. And this becomes relevant, we think, because the contention of the prosecution is that one of the gloves was lost in this struggle, supposedly. There are identifiable palm prints. It's no match to Mr. O.J. Simpson. Our experts will testify there are different patterns of shoe imprints at this scene, indicating perhaps more than one person. No mention of that thus far. We expect that to be the testimony. There are no hairs on the Bundy glove that are matched to Mr. O.J. Simpson.
Do we know the blood type of the son? Is it B? Because there's blood type B on both Nicole and Ron, and OJ is not B, and neither are they. So whose blood is that?
There are negroid hairs on the knit cap at Bundy that do not match Mr. O.J. Simpson. But the prosecution has never, to this date, done any DNA tests, as far as we know, rather, on the Bundy glove. Testing has been slow. That when the investigators arrived at the scene of these double murders, she talked to you about somebody named Detective Risky. Well, Risky may have been the officer who came there, but this case was assigned to Phillips and Furman. This was their case. This was West Los Angeles homicide. Phillips and Furman. That it was transferred from them because of the high-profile nature of the case to robbery homicide thereafter. But Phillips and Furman continue to play an active role in this case. You'll hear very, very little about an officer Risky. But one of the interesting things I think you'll find about this crime scene is the dearth or lack of any photographs, examination, or investigation inside that house. I don't think you'll find one photograph from inside that house. There will be some evidence that the officers who arrived at that scene, shortly after finding these bodies, found a partially melting cup of ice cream from Ben & Jerry's. We don't have that. I don't know that there were no pictures taken of it, so we don't have any way of seeing how much it was melted. We're precluded from that at this point. This was found near the back of the residence of the Bundy home. You heard a lot yesterday about blood drops at Bundy. Well, as you could tell, there are obviously thousands and thousands of drops of blood at that scene. Ms. Clark talked to you about 5 blood drops. But we expect the evidence to show that the blood drops that they found had very, very little DNA. And in the graphic soon I will try to demonstrate for you the amount of the DNA found in these blood drops, which meant that these blood drops, according to our experts, were either old or degraded, contaminated by people who collected them and tested them. And of course, the blood drops at Bundy, or in an area where Mr. Simpson and his children have obviously been on many occasions. There were tire tracks in the back of the house, which have not been matched to any of Mr. O.J. Simpson's vehicle. Now, one of the things that we expect to show during the course of this presentation of evidence is that there was, in fact, a major struggle. And Mr. Goldman fought valiantly. He was apparently physically fit, 5'10" and 170 plus. He was stabbed a number of times, perhaps 30, and there was blood on his hands and arms. He had a number of defensive wounds. And the experts will testify that you would expect that the perpetrators, that Mr. Goldman's blood would be all over the perpetrator's clothes, hair, all over his body. In fact, he would be saturated with Mr. Goldman's blood. And of course, under the prosecution's theory, the perpetrator was driving that Bronco that night. There's no evidence of Goldman's or Nicole Simpson's bloodstains inside that Bronco of the amount that you would expect, given this situation, that the pattern of blood that they talked about yesterday, the small, very small pattern of blood in that vehicle, is very consistent with what I expect you will hear is a statement made by Mr. Simpson. Now, Ms. Clark went on yesterday and said that with regard to the DNA evidence, she talked a little bit about DNA. She didn't talk about or make a distinction for you between the RFLP, the restriction fragment length polymorphism, or the polymerase chain reaction, the PCR, of which our expert basically invented it. But I think what you'll find is this is very, very sensitive evidence that is then Xeroxed up, molecular Xeroxing, and we'll talk about that a little more later. We think the evidence will show that the pattern before I tell you that, I think the evidence will also show that on the steering column of the Bronco, item number 29, the people's exhibits, I don't think you were told this yesterday, that they did not talk about a DNA mixture consistent with, not necessarily a match, consistent with Mr. Simpson and someone other than Nicole or Ronald Goldman, some other person. That with regard to Rockingham, Mr. Simpson's residence, again, I expect there'll be testimony that Mr. Simpson did in fact cut his finger in some place where I'm pointing now, near the end of this middle finger. And he so told the police that evening, on January 13th, and that he went out, he did it either as he's about to leave or whatever, he went out to the Bronco to get his cellular phone. That what I think you'll find and what I think the evidence will show is that the reason there was no blood coming up the stairs, and this carpet in this house, I think you'll find the evidence will show, is largely white, largely very light. If you have a jury view, you'll be able to see it for yourself. You didn't find any blood other than what you saw outside and just in that entryway. And I think you'll find that leads toward the kitchen. And there'll undoubtedly be testimony with regard.
Guilty. Guilty. What kind of psychopath has white carpet? Guilty. No, we don't have to see any more. Thanks for watching OJ with us, guys. It's over. We're done.
To that injury, if any, occurring before he ever left for Chicago. There will be, as I understand the evidence, no trace of blood on the white carpet upstairs or up on the stairs or upstairs. No trace of blood on the white carpet from any bloody shoes. No trace of blood on the white carpet from any bloody pants or shirts. And no trace of blood on this white carpet from any bloody socks. The evidence will show that in an effort to find any evidence, not to exclude, but to include Mr. Simpson, They searched everywhere in the area in Los Angeles. They searched in Chicago. They searched everywhere they possibly could think. And they did not find any weapon or any clothes because Mr. Simpson, the evidence will show, did not have them. They took apart traps and pipes from his sink, showers and plumbing, and searched everywhere for these various things. The evidence will also show that with regard to Miss Nicole Brown Simpson,
No objection.
Mr. Hodgman? All right.
I should point out that the people in their investigation did in fact check the sink area and the shower area and some areas in the bathroom, in the bathroom floor, for areas for an indication there may be blood in those areas. Some of those tests came back positive. There will be testimony. There will be testimony with regard to this entire area as to those tests and what other things will test positive for. The court will, at the appropriate time, allow this to be discussed. Now,
Proceed.
thank you. With regard to Ms. Nicole Brown Simpson, which I was about to talk about, the testimony, we believe the evidence will be that because of the nature of her injuries, a lot of blood came forth, so that the perpetrator would in all likelihood be covered and soaked again with her blood. We think this will become important again when you determine the absence or lack of blood, certainly with regard to Mr. Simpson, not perhaps regarding the perpetrators of this offense. Ms. Clark yesterday talked about a mysterious disappearing black bag. We expect there will be videos in this case that the black bag I presume she was talking about was Mr. Simpson brought back with him from Chicago. It can be seen clearly with that video, with that black bag. And I believe it was in police custody, certainly at one point. I know they had it in their custody. And so it didn't seem to us that's a big mystery, but we'll have to look at the evidence as it develops. But we're not aware of any missing black bag that Mr. Simpson has or whatever. So looking at the evidence at Rockingham, and then there's this Rockingham glove that's supposedly found in an area that you saw some pictures about yesterday. Mr. Simpson's home. It's a very, very narrow pathway on the side of his house. You saw the pictures of this glove, which was on top of some leaves. There will be no testimony, as I understand it, about any blood drops leading to and from that. But as I expect the evidence will show, there's a fence right up there close by this blood drop. This pathway leads basically to a backyard area that's kind of basically enclosed. I think there's maybe a gate on one side. I think the evidence will show if somebody wanted to come in the house on that side, and you'll see this when you go out there, there are at least 2 doors on that side that somebody could go right inside the house by climbing over a fence or anything of that nature. You will see the evidence, and again, you will be the one who can help make those facts. But with regard to this glove, which was, and then again, I think that, let me try to set the record straight for you. This glove was not found by them or the officers or whatever. This glove was found by Detective Furman. He found it, and he then individually took these other officers back there supposedly to see it. They had supposedly brought a photographer over there to take pictures of it. Although you didn't hear that yesterday, those are the facts as I understand them. As I said, there's no blood trail to these leaves. The leaves don't appear to be disturbed. There's no evidence of any hairs.
The glove being back there does confuse me too, because if I were in a hurry to get to my own home, I would go in. I have fences around. Nothing would make me go over one of the fences. I would go into the front. I would go in the way I always do if I'm in a hurry. Um, I don't know why I would jump over a fence. And and especially right there, right outside of Cato's bedroom window when the front door is so far away from there.
Fibers on this fence, and there was testimony, and will be testimony, I believe, that there were cobwebs in this area beyond this glove. Presumably, one could infer that nobody had been back there for some period of time and knocked those cobwebs down. With regard to this glove, there's also on this glove a Caucasian hair on this glove that does not match the hair of either Nicole Brown Simpson or Ryan Goldman.
But there are hairs that do match them as well. You forgot to put that in there.
And Ms. Clark told you yesterday that how samples are collected and who collects them are unimportant. I alluded to this briefly, but we think that the evidence will show that the Nobel Peace Prize winner who invented this technology will tell you it is of paramount importance how this is collected because of the sensitive nature, how very small. You can't even see some of these samples. You'll hear that testimony from Dr. Carrie Mullis. You will also hear testimony from a Dr. John Gertis, another leading expert from Denver, who we expect will come to testify. It seems to me that any attempt to, in the evidence, to make it seem as though PCR technology and DNA and RFLP is easy to understand, it's very complex. I think from both sides, we want to do everything we can to make this as clear as possible. I think that you will hear testimony, and I ask you, of course, to keep an open mind as you hear the experts on both sides, and I think you'll get a clear picture of this particular evidence. I mentioned before this crime scene and the number of people who were allowed to walk through there, many with just their shoes on, walking right through the blood, some who had those little booties on, some had gloves, some didn't have gloves, picking up the evidence, which will become very relevant and important to you as you hear from the experts about the contamination aspect of this and what it means, how easy it is, a sneeze, a touch, whatever, for this evidence to become contaminated. You'll hear about this new technology, but you'll hear also that the expert who invented it doesn't believe it's being properly and appropriately applied, and is not ready, perhaps, in a forensic sense to be used. That is, to be used at a crime scene and then brought to court. When Ms. Clark talked to you yesterday about the medical uses of it, she talked about amniocentesis, and that was nice. But in amniocentesis, you have known individuals. You know who the father and the mother are. At least you better know who they are. I was hoping that when you take the fluid, you know that.
But I had a tequila sunrise yesterday. It wasn't beer, but it was orange juice because I'm supposed to drink a lot of vitamin C and tequila.
Lab, a clean setting, it's not like a crime scene or whatever. You will hear the distinction, as I said before, this 21st century cyberspace technology used by people poorly trained in the field.
Nan, aren't you supposed to drink orange juice when you're sick? Isn't that right? If you're sick and you have a choice between orange juice and beer, which one should you choose? And then if you add tequila and just a tiny bit of grenadine to that orange juice, that's okay, right?
We're using like 19th century techniques to collect it. Ms. Clark mentioned to us yesterday about Jurassic Park. This is not a movie. This is not, you can't, and it would be fantasy to think that you could take and make dinosaurs with DNA. Nobody's done that. That's a movie. It's not real life. She talked to us about the czars in Russia and that sort of thing. Well, it's one thing to look for bones. There is a technology that you hear about was not used in this case. It's a different technology altogether, some kind of sequential DNA testing, mitochondrial, and I won't bore you with the term. That's not used, but the experts will tell you. That's not relevant to the proceedings here, what was done here. So with regard to the claim that every effort was made to exclude Mr. Simpson, we think the evidence will show that that's not what happened in this case. We have to keep an open mind. We think the evidence will show that when test results pointed away from Mr. Simpson, they concluded that something must be wrong with the test. Our experts will tell you that there are huge interpretation problems with many of the tests performed in this case. This is particularly true where there are mixed samples containing blood or other biological material from more than one person. We expect to show that the results of some of the tests in this case are so ambiguous that two different scientists will come to two different conclusions with the same results. As I said earlier, given Mr. Simpson's statement to the police, the evidence of any blood in the Bronco is far more consistent, we believe the evidence will show, with Mr. Simpson's innocence than any guilt. And the fact that there's almost no blood of anyone else, if any, in that Bronco is just the opposite of what you'd expect if somebody committed a crime and used that vehicle as a means of transportation. Now, to conclude then with regard to my discussion of Ms. Clark's opening statement, a number of things were said to you yesterday, and Judge Ito at the end of the day asked you to keep an open mind. As I thought about this case last night, I was concerned, just for a moment, as I thought about, well, we didn't get a chance to talk to them yet, through circumstances beyond our control. But what quickly came to my mind was the fact of a jury that we tried to work and pick since September has been so patient, would keep an open mind. And I'm sure you've done that. That's all we're asking. But not only from last night to today, but
We have not kept an open mind, guys. We just haven't.
until you hear the end of the case. Because you remember, and part of what I'm saying to you today, is that the case won't be over till you've heard all the evidence and the summations by the lawyers. And all of you have said that would be unfair to make up your mind before that. And I think both sides would agree with that. See, in her conclusion yesterday, she'd indicated that something about it was devastating, proof of something other, if you remember. It seems to me, as I thought about what she said, that the fact that there is no blood where there should be blood is devastating evidence of innocence. And we'll be talking more about this, that the fact that blood voluntarily given by a defendant mysteriously disappears when it should be there is devastating evidence that something is wrong. And finally, it seems to me that the fact that blood mysteriously appears on vital pieces of evidence and it's predicted what the results will be regarding DNA when that evidence is still in the police lab is devastating evidence of something far more sinister. Now let's turn our attention again, if we could, to the laser disc showings. Let me start this part of the presentation quickly by showing you again some trails that lead to innocence that weren't pursued by the prosecution team. And, Your Honor, I'll be moving ahead, and we'll call out the number if we can. Before we do that, Mr. Douglas, can you retrieve the envelope? Let's go.
I bet you could have. I bet you would have done a great job. Well, we can still rate him, guys. We just have to do it manually. Well, I'm going to put the link up in 25 minutes, and then we're all just going to go.
Yes, with the court reporter, please.
There's 20 of us, Fozzie. There's 20 people. We can all just go. We can just click the link. It's really easy.
All right, thank you, Madam Reporter. Mr. Cochran, you may continue.
Thank you very kindly, Your Honor. I think we were, just before we get to the disc showings, I just would indicate to you that I expect there'll be evidence, as I've indicated to you somewhat already. There was an intensive search in Mr. Simpson's home looking for any kind of a weapon, presumably a knife of any kind. And I think that during the course of the trial, there'll be evidence that'll become very relevant to you with regard to this entire area and the people's theory with regard to knives. Now, we've now moved on, Your Honor, to report dealing with the fingernail clippings.
B1A.
I had talked to you earlier about this analyzed evidence report, and this is the actual report of the substance found under Miss Nicole Brown Simpson's fingernails.
That was B1B.
That's not good. It's good now.
That was B2C. I'm sorry, D1C.
What 84A and 84B, I think the 18A is a typo. Could not have come from Nicole Brown Simpson, Ronald Goldman, or O.J. Simpson, as I indicated to you earlier. Mr. Harris?
D2A, and we have to,
There is the next photograph it's coming up. May I have just 1 second?
Debbie, he had surgery and he's trying to heal from it.
Do you need the reporter? All right. Thank you, counsel.
Thank you, Your Honor. Since there's a record, Your Honor, Mr. Douglas has indicated to me I need to read the graphics into the record. I'm not sure that our court reporter is getting all these. It's item 84A and 84B. It says 18A, which I understand is a typo, could not have come from, quote, Nicole Brown Simpson, Ronald Goldman, or O.J. Simpson. Now, there's another, the next one coming up, I was going to ask Ms. Clark. Your Honor, you may want to hit your kill switch on this next one, just briefly.
All right.
This next photograph is what I alluded to earlier as the blood on Miss Nicole Brown Simpson's back, and it's an indication that testimony is from our expert that this blood on her back in that position was in fact never preserved, neither by the LAPD nor the coroner's office, and was in fact wiped off and never preserved or saved. Thank you, Mr. Harris. To conclude, then, Ms. Clark's opening statement, I'd like now to move to a discussion of what I expect the evidence to show vis-a-vis the defense in this matter. You may have asked yourself, in hearing this evidence this far, who then is O.J. Simpson? That's an answer that will come, hopefully, during the course of this trial. I can tell you that the evidence will show that he is a 47-year-old man, father of 4. In many respects, he's the living embodiment of the American dream. I think that you will hear testimony and evidence about certain other things you don't know about O.J. Simpson that may become relevant during these proceedings. There will be testimony that O.J. Simpson suffers with chronic rheumatoid arthritis. He's one of the leading rheumatoid arthritis doctors in the country, and that when he's in remission, he can function fairly well, but when it's an acute phase, he has great trouble functioning. We expect there will be testimony that on the date of June 12th, Mr. Simpson was involved in the acute phase of his rheumatoid arthritis. And on that date, after he had played golf, the problems with his hands were so severe he could not shuffle the cards where he played gin rummy at the country club thereafter. We expect that will be, the evidence will be adduced. You will
I don't think the point he tried to get across came across the way he thinks it did with that statement.
hear from several of his doctors who are on our witness list to further buttress the fact that he was in an acute phase of this rheumatoid arthritis shortly after he came into custody. Mr. Simpson had surgery in which some lymph nodes were removed. These lymph nodes were caused by the rheumatoid arthritis, contain white blood cells.
But he was playing golf.
In addition to that, I alluded to the fact earlier that he was perhaps the greatest running back in the history of the NFL, with all kind of records. But you pay a price, and the evidence will talk about that price that he paid. On his left knee, he's had 4 surgeries. We expect you'll hear from his doctor about the effect of those 4 surgeries, about the effect of what he has in addition to the chronic or acute rheumatoid arthritis. He has osteoarthritis in his legs. The evidence will be he suffers with rheumatoid arthritis in both of his wrists. And so, things are not as they always seem. And as you see him sitting there now, he does in fact have problems with movement. There will be testimony that he plays golf, that he can no longer play tennis, that when he plays golf, he always has to use a golf court. Can't walk 18 holes. We expect there'll be testimony that he's perhaps one of the only few people in the world who's able to use a golf court at Pebble Beach because his doctor had to write such a letter. And so, I'd like to demonstrate that for you, the extent of his knees, and say to you that what no NFL, National Football League defense could do, Mother Nature and Father Time have taken their toll. Doesn't mean he can't move around, but I think there'll be evidence of the limitations now imposed upon him by virtue of his career, by virtue of this disease that he suffers. And I'd like, at this point, to have Mr. Simpson come over to the jury so I can demonstrate the problem with his knees. If I could, with Ms. Deputy McNair.
right, ladies and gentlemen in the back row, if you want to stand up, feel free to do so.
For the record, so the court can't see it, but Mr. Simpson is demonstrating for the jurors his left knee, and I think there's an indication that there are scars going up and down, sideways, and there's one behind, I think, and one in the front. I think there's an indication that he's had at least 4 surgeries on that particular knee. While you are here, Mr. Simpson, I would like for him, Your Honor, to be able to show his, what you just put, his middle finger of his left hand, Your Honor.
Yes.
I can't mark this as an exhibit, but I can at least do what the court allows me to do. I want to show his middle finger of his left hand.
Let me caution the photographers to use extreme caution.
Yes, Your Honor. Thank you. Thank you.
All right, thank you, counsel.
So they're saying he's not able to commit these crimes because he's disabled.
In addition to what you've just seen with regard to his left knee and the condition I told you about, Mr. Simpson is dyslexic. He suffered with dyslexia all of his life. And you know what that is, where he tends to, when reading, things get reversed and transposed and backwards. Despite all of that, as I've said, you see what he's done with his life. I think the next area we'll deal with, and Mr. Douglas will put the diagrams up. You've heard and will hear testimony that on the evening of June 12th, 1994, Mr. Simpson had a trip planned to Chicago, Illinois on American Airlines. The plane was due to leave at about 11:45, and in fact, it did leave around that time. Mr. Simpson got to the airport, got on the plane. That's what you. And what we seek to illustrate here is his demeanor and all the people on the plane and their relevance to this particular case. We expect there will be testimony that he was one of the last people to board the plane that particular evening, headed east to go to Chicago. That he took a seat, and he was fortunate enough to be sitting in first class, and that sitting very close to him was a young man by the name of Steve Valerie, whom I believe you will hear testimony. Steve Valerie was very impressed that he was sitting next to O.J. Simpson. So we had occasion to watch Mr. O.J. Simpson, watch his hands. He'll tell you he didn't see any major cuts on his hands or anything of that nature. But he observed his demeanor, observed how he acted, observed how he handled himself during that particular time. That there was a man on this flight by the name of Howard Bingham, a man famous in his own right. It's Muhammad Ali's personal photographer, lives here in Los Angeles. But Howard Bingham was on his way to see Muhammad Ali. He left his seat back here and walked up, had a conversation with Mr. O.J. Simpson. He too will come in and tell you how Mr. Simpson appeared on June 12, 1994, 11:45 to the time that flight got there, Chicago. And there are others, as you might imagine, who've seen him. Particular interest is there's a captain of this flight, Captain Wayne Stansfield.
Keep talking,
Found
Critter.
out
We
that O.J.
love it.
Simpson was flying to Chicago. And he came out of the cockpit. You know, you always worry when you see the pilot come out. But I mean, that presumably means there are a couple others who can fly the plane. So he came out, and he got Mr. O.J. Simpson's autograph on the flight log.
Tú estás muy bonita. I speak perfect Spanish. Victoria, I love.
So he had a chance to see his hands, had
I had a great time last night, Victoria. Thank you.
a chance to observe him. He signed autographs as he got out of the limousine for the sky caps. Remember, he'd gotten some money so he could give the sky caps some money. There'll be testimony that he had $10 or whatever. The sky cap had no change, and he gave him that, of course. And you'll hear about this flight. You'll hear about this man's demeanor. Hear about how he handled himself, how people watched him during this period of time. Mr. Valerie especially was looking at his hands because he thought that O.J. Simpson would have a championship ring on his hands. So he had occasion to look at him, watch him, observe him, as did Howard Baker, who knew him before this time, as did the pilot, and as did all the other people who came in contact with him. Thank you, Mr. Judge. The next graphic, which we think will be relevant to you in the course of the presentation of the evidence. This time, as you can see from the graphic, Your Honor, we're not getting the numbers covered.
The first one was 203. This is 204.
Referring to number 204, and you can see the legend is going from east to west this time. This is after the evidence will show Mr. Simpson has been told that his ex-wife has been found murdered. You will see the difference in this man's demeanor and how he reacted and how he handled himself. From the time he got that call from Detective Phillips, found out his ex-wife had been murdered, and how he reacted, what he said, his concern about his children, how he called and tried to get the first flight out of Chicago, how they had a flight too late for him at 10 o'clock or something. He insisted on an earlier flight. He wanted to come directly back to Los Angeles as soon as possible after this conversation. He made calls while on the way back from Chicago to Los Angeles, try and find out what had happened. And we'll be calling certainly more than one witness on that flight. It's very interesting. Seated right next to O.J. Simpson on this flight back is a lawyer by the name of Mark Partridge. Mark Partridge sat with him the entire time. He will come in here, he's a lawyer in Chicago, to tell you about this man's demeanor. One of the interesting things.
Good night, Snoopy. Uh-oh. Can you guys hear me at all? There we go. I think we're back now. I don't think my computer liked the two streams going at the same time. We are going to do maybe 3.5 more minutes, and then we're going to jump over. Actually, this is a good stop. I think my computer is telling me this is a good stop. So that's how much OJ we get today, guys. We're going to hop over because Courtroom Cat is about to start.
About this, I think you'll find.
Whoop, that was the wrong button. Everybody just click that link. It looks like this. You should all be here. Come watch Courtroom Cat. We're going to have a good time. Oh man, that looks good, doesn't it? Unless that's not ice cream and that's really just butter, then that's not good. But I think it's ice cream. You gotta click the link yourself. You gotta click it like you mean it. And I'll see you guys. It starts in 3 minutes, so you better hurry up. Thanks for coming out, guys. Thank you so much. I will see you very soon. Victoria, have the best day at work. We're gonna be watching. Bye, guys.